Click send, and a piece of intimate media or a destructive lie can duplicate across hundreds of servers in seconds. Digital harassment spreads at the speed of light, leaving victims scrambling to contain the fallout. But if you try to fight that digital fire using the traditional court system, you run into a massive pacing problem. Lawsuits move in slow motion, often taking weeks or months just to schedule an initial hearing. Waiting a month for a judge's time means the photos are already permanently archived by third parties, the data is sold, and the reputational damage is fully locked in. In an online crisis, time is the absolute enemy. By the time a standard legal mechanism catches up to the internet, the victim has already lost everything they were trying to protect. Civil law usually operates on a simple premise. If someone wrongs you, you sue them, and the court forces them to pay you financial damages after the fact. A check for damages does not scrub private data from a search engine, and it certainly doesn't unpublish an intimate photo sent to your employer. Money cannot undo a shattered reputation. To solve this mismatch, the legal system relies on a specialized mechanism, the urgent harassment injunction. Instead of waiting to calculate compensation after a life is ruined, this tool forces the justice system to focus entirely on immediate, hard prevention. When a court grants an injunction, it creates a legally binding perimeter around the harasser, dictating exactly what they can and cannot do in the real world. As this diagram shows, injunctions take two functional forms. A prohibitory injunction drops a wall, actively blocking a person from publishing material. A mandatory injunction works in reverse, forcing the person to take a specific action, like deleting a live post. Because the threat is moving so fast, the application process can too. If a malicious leak is imminent, a judge can grant an interim injunction outside normal working hours, or even on a Sunday. This aggressively freezes the harasser in place, securing the situation and bridging the highly vulnerable gap between the initial threat and a full court trial. But taking legal action introduces a terrifying risk for the victim. Normally, when you file a claim, the other party is notified. If a harasser gets a legal notice in the mail, they might panic and publish the blackmail material immediately in retaliation. To neutralize that risk, lawyers deploy a specific tactical countermeasure known as a without notice or ex parte application. Looking at this timeline, a without notice application allows the victim to present their case on a hidden legal track. They can secure a binding court order in total secrecy long before the harasser even realizes a legal fight has begun. By removing the harasser's chance to react, the element of legal surprise effectively disarms them. They are trapped by a court order before they can hit post or destroy crucial evidence. There is still one massive vulnerability: the public record. Fighting a privacy breach in open court usually requires putting your own name and the very details you want hidden into public documents for anyone to read. To prevent the legal process from becoming a second violation, the court can issue specific privacy injunctions and anonymity orders. As we see on this digital docket, these orders physically alter the public record. They strip out the real names of the parties involved and replace them with anonymous ciphers, like XYZ versus GHL, completely locking out the media and casual snoops. These tools ensure a victim can fight back aggressively without sacrificing whatever privacy they have left just to secure their physical or reputational safety. Because these interim orders bypass standard timelines and operate in secret, judges do not hand them out lightly. You have to clear a very steep evidentiary threshold. Specifically, you have to prove three distinct principles: that you have a valid underlying legal claim, that granting the injunction is logically just and convenient, and that financial damages would completely fail to fix the problem. Think of the court's threshold like this verification gate. Proving those three principles requires rock-solid evidence: affidavits, screenshots, and timelines. And the phrasing must be absolutely flawless. Omitting a critical fact or drafting an ambiguous request means the judge will throw the application out. Having the theoretical right to an injunction is totally useless. What matters is the precision required to execute the application and convince a judge before the clock runs out. Navigating an application this fast and with stakes this high requires legal teams who specialize entirely in digital crises, not general practitioners. Cohen Davis solicitors are elite experts in internet law. They have a proven track record of securing landmark privacy and harassment injunctions, often succeeding in complex situations where a court has never granted one before. If you are facing an imminent threat to your privacy, reputation, or safety online, you need to take back control. Call Cohen Davis today at 0800-612-7211. Simply knowing these powerful legal tools exist is the first step to neutralizing a digital threat. Like and subscribe for more legal breakdowns, and stay safe out there.